Respected friends, fellow citizens, distinguished members of the legal profession, academics, journalists, civil rights activists, and my young friends, ladies and gentlemen, good morning to all of you. Today, I am speaking about something more fundamental than any political slogan, and that is a constitutional response to the Dimagi Naxal, intellectual Naxal narrative. Dissent is not a disloyalty. My friends, I wish to speak about this constitutional right to dissent. The Prime Minister of India, Modi, in his Independence Day speech from the Red Fort on August 15, 2026, used the expression Dimagi Naxals and called for such elements to be identified and isolated. He presented them as an ideological threat and that persists even an armed Naxalism is being brought under control. We must take that statement very seriously, my friends, but we must also examine it constitutionally. Let me make one thing absolutely clear at the outset. India must combat armed violence. No constitutional democracy can permit murder, terrorism, armed insurgency, or violence against citizens or security personnel. But there is another equally important principle. India must not conflate violence with dissent or insurgency with intellectual disagreement. That distinction is the foundation of our constitutional democracy. My friends, there is a profound difference between an armed insurgent and a citizen who criticizes the government. There is a difference between violence and protest. There is a difference between conspiracy and advocacy. There is a difference between incitement and disagreement. And there is a difference between opposing the government and opposing the nation. These distinctions cannot be erased by political vocabulary. They cannot be erased by calling someone as an urban Naxal. They cannot be erased by calling someone as a Dimagi Naxal or intellectual Naxal. And they certainly cannot be erased by repeatedly questioning the patriotism of those who disagree with the government. Our constitution provides answer, my friends, for this. Article 19, subclass 1, subclass A guarantees every citizen the freedom of speech and expression. Article 19, subclass 2 permits reasonable restrictions but only on constitutionally specified grounds and subject to the test of proportionality and reasonableness. Therefore, the government cannot introduce an additional restriction in the following form. You may speak, but you must not criticize us. Such restriction does not exist in the Constitution. The Constitution does not state freedom of speech is available only to those who support the government. It does not state that academics may speak only when their research aligns with the government policy. And it does not state journalists may question the government only when the government approves the question. And it certainly does not state those who challenge the government ideology are ideological enemies. My friends, the Supreme Court has clarified the position many times. In Kedarnath Singh versus State of Bihar, the Supreme Court drew a crucial constitutional distinction. Strong criticism of the government measures or public officials does not become criminal merely because it is expressed in strong or even harsh language. The constitutional threshold is crossed only when speech bears a proximate connection to the incitement of violence or public disorder. And likewise in Shreya Singhal versus Sr. of India, the court further refined this framework. Discussion, advocacy, incitement. Discussion is protected. Advocacy is protected, and even when it is unpopular. It is only when speech crosses into incitement that Article 19 subclass 2 is legitimately triggered. This is the constitutional Lakshman Rekha. It applies equally to all. So let us ask, if I say that a government policy is anti-poor, am I an Naxal? If a lawyer argues that the executive action violates the constitution, is he a Naxal? If a professor criticizes government policy, is she a Naxal? If a journalist exposes corruption, is he a Naxal? If a student protests an examination system, is he a Naxal? If a civil rights activist demands police accountability, is he or she a Naxal? If a bureaucrat refuses to comply with an illegal order, is he or she a Dimagi Naxal? No. The answer must be no, because the Constitution protects the right to question authority. My concern is not merely the phrase. My concern is the consequence of such phrase entering public discourse. A label can do what an argument cannot. An argument invites response. A label demands rejection. If I criticize a government policy, the government should respond to the substance of that criticism. But if I am labeled as an ideological extremist or Dimagi Naxal, the nature of the debate changes. The question is no longer, is the argument valid? It becomes, is the speaker loyal? That is the dangerous shift. Because democracy is not a test of loyalty, my friends. Democracy is a constitutional system of accountability. And there is another danger. When government repeatedly describe critics as internal enemies or anti-nationals, citizens may begin to self-censor. A professor may refrain from publishing. A journalist may avoid investigation. A student may hesitate to protest. A civil rights activist may remain silent. A bureaucrat may avoid raising concern. A lawyer may decline to challenge the authority. And gradually, without any formal constitutional amendment, the democratic space begins to shrink. This is known as the chilling effect. The Supreme Court has recognized that vague and overbroad restrictions on speech can themselves suppress the expression as citizens begin to silence themselves out of fear or uncertainty. The reasoning in Shreya Shingal is particularly instructive in this regard. My friends, India must also remember Father Stan Swamy case. He was arrested by the National Investigating Agency on October 8, 2020 in connection with Bhima Koregam Elagar Parishad case and passed away in judicial custody in July 2021 in incarceration. Whatever one's view of the case, his death compels every constitutionalist to confront a difficult question. How far should state power extend before constitutional safeguards of liberty becomes indispensable? National security is essential, of course, but national security cannot become a blanket justification that displaces constitutional rights. The greater the state's power, the greater its obligation to act strictly within the bounds of law. Friends, the government is not the nation. Let us repeat that. The government is not the nation. The government is a constitutional authority. It derives its legitimacy from election. It exercises power from a limited constitutional term of 5 years. It is subject to the scrutiny by the parliament. It is subject to the criticism. It is subject to the replacement. The nation endures beyond governments. The constitution limits governments. Therefore, when I criticize the government, I am not necessarily criticizing India. When I oppose a government policy, I am not opposing the nation. When I challenge an executive action, I am not undermining the sovereignty of the nation. When I approach a constitutional court, I am not acting against the state. I am exercising citizenship and my right. What did our freedom fighters teach us? My friends, it should be remembered that our independence was not achieved through obedience. The freedom movement was built on the courage to question colonial authority. People protested, people wrote, people organized, people went to prison, people challenged unjust laws, people demanded accountability. If dissent had been equated with disloyalty, India would not have become independent, my friends. Therefore, on Independence Day, we must remember this enduring truth. The India born of dissent must never become India afraid of dissent. My friends, this brings to me up to our young people. India's youth have legitimate questions. They seek quality education. They seek employment. They seek fair examinations. They seek opportunity. They seek institutional accountability. They seek a future. When young people raise these questions, the government must respond substantively. If there is an examination controversy, it must be addressed. If there is institutional failure, it must be investigated and corrected. If there is police excess, it must be examined and action should be taken. If there is unemployment, it must be confronted. If there is corruption, it must be prosecuted. If a policy is unpopular, it must be defended with facts. Do not respond to the questions with labels. The appropriate response to the dissent is dialogue. And what about us in the legal profession? Friends, as lawyers, we occupy a distinct constitutional position. The bar is not merely a profession. The bar is a guardian of constitutional governance. Our duty is not to agree with every citizen. Our duty is to ensure that every citizen retains the right to disagree. We must defend the unpopular because constitutional rights are meaningful only when they protect the unpopular. We must defend the critic because tomorrow that critic may expose wrongdoing. We must defend the student because tomorrow that student may become the lawyer or a judge safeguarding the liberty. We must defend the journalist because tomorrow journalism may reveal what others cannot say. And we must defend the dissent because power without accountability is incompatible with the constitutional democracy. Let me therefore state this very clearly, my friends. Dissent is not disloyalty. Criticism is not a sedition. Advocacy is not incitement. Disagreement is not the extremism. Academic freedom is not insurgency. Peaceful protest is not terrorism. Opposition to the government policy is not opposition to India. And questioning the government is not questioning the nation. Friends, there is one more principle we must reaffirm. The constitution does not belong to the government. It does not belong to the opposition. It does not belong to any political party. It does not belong to any ideology. It belongs to we the people of India. And therefore, every government, irrespective of political affiliation, is bound by it. That is the essence of constitutional supremacy. Then the real question. So I ask today, what exactly is a Dimagi Naxal? If it refers to someone who supports armed violence, the law already provides adequate mechanisms to address it. If it refers to a membership in an unlawful organization, the law provides for investigation and prosecution. If it refers to incitement of violence, the legal system is equipped to deal with it. But if it is used to describe a professor who disagrees, a journalist who investigates, a lawyer who challenges, a student who protests, a citizen who questions, or an intellectual who thinks differently, then I submit that person is not the Dimagi Naxal and he is not the enemy of the nation. That person is exercising a constitutional right fundamental to the democracy. So, my friends, a government can withstand criticism. A government can withstand opposition. A government can withstand uncomfortable questions, but democracy cannot survive if citizens are afraid to ask them. Therefore, our concern is not against any individual leader. Our concern is not against any political culture that seeks to place the authority beyond scrutiny. Our allegiance is not to any political personality. Our allegiance is to the Constitution. Our patriotism is not measured by the volume of the praise for the government. If it is measured by the courage to uphold the constitutional values even when it is inconvenient. And finally, if tomorrow someone asks me, my friend, are you a Dimagi Naxal because you criticize the government? My answer will be no. I am a responsible citizen. I am governed by the Constitution. I am protected by Article 19. I have a right to speak. I have a right to question the government. I have a right to disagree. And as a lawyer, I have a constitutional duty to speak when liberty is at stake. So because governments changes, political parties change, leaders change, policies change, but the Constitution must endure. Let us therefore defend in India where the government is strong but accountable, in India where the state is powerful but constitutional, in India where citizens are free but responsible, in India where students may protest, academics may question, journalists may investigate, lawyers may challenge, and citizens may dissent, because that is not the weakness, that is the democracy. And let us send one clear message from this, one clear message today, my friends. Dissent is not the disloyalty. Questioning power is not anti-national. Criticism of the government is not the criticism of India, and constitutional citizenship is never a crime, or a citizen cannot be called as a Dimagi Naxal or intellectual Naxal just because he questioned the government. Jai Bhim, Jai Constitution, Jai Bharat.